Hello, everyone. Hi, welcome to the latest edition of CWS Wildlife Chronicles. My name is Vinni Jain, and I'm a research fellow at the Center for Wildlife Studies. The Center for Wildlife Studies is an internationally recognized center of excellence in the areas of wildlife research, conservation, policy, and education. And today we have our speaker, Praveen Bhargav.
Right.
Praveen Bhargav has been involved in wildlife conservation activities since 1982. He co-founded Wildlife First, a non-for-profit conservation organization, and serves as its managing trustee in a voluntary capacity. He has represented Wildlife First on the National Board for Wildlife, the highest advisory body on wildlife chaired by the Prime Minister. He was a part of the subcommittee on amendments to the Wildlife Protection Act 1972. He presently serves as a member of the Inquiry Committee on Sagar Elephant Corridor, constituted by the Honorable Supreme Court of India. Among many, he's familiar with the Wildlife Protection Act 1972, Forest Conservation Act 1980, Indian Forest Act 1927, the Scheduled Tribes and Other Traditional Forest Dwellers Act 2006, and related rules, policy, and judgments of the Supreme Court and other forest and wildlife cases. So, hi, welcome, Praveen.
Thank you.
Yeah. CWS has been doing webinars since 2020. And if you want to access any of our previous webinars, you can access them on our YouTube channel. And if you have any questions for us or for our speaker after the webinar, you can email us at outreach@cws.cwsindia.org. So I'll start with the questions. So Praveen, what is the Wildlife Protection Act and what is the historical context behind the law being passed in 1972?
Yeah, good evening, everybody. So thanks to CWS for inviting me. So the historical context is as follows. Many people may not be aware. Everybody knows that the act came into force in 1972. But the context in which it was enacted is important because at that time in 1972, wild animals and birds was listed in the state list. It was not in the concurrent list. And I'm assuming that all of you know that legislative competence is essential while enacting a law. So the central government was not competent to enact a law on wild animals. But how did they overcome this constitutional mandate or the constitutional requirement? Article 252 of the Constitution provides for two or more states to pass a resolution and empower the central government to enact a law on a subject which is in the state list. And this procedure was followed, and therefore, I think if I recollect correctly, 11 states passed a resolution, and thereby the central government in 72 was able to enact the Wildlife Protection Act. Subsequently, in 1976, wildlife and forests came onto the concurrent list. And today, both central government and state government can enact laws pertaining to wildlife and forests. And as long as the state law is not inconsistent with the central legislation, it is perfectly okay. But if it is inconsistent, it is void to that extent for subjects which are in the concurrent list. So therefore, this was the historical context. Subsequently, the law went through many amendments, has gone through many amendments. 91 was a major amendment, 2003 was a major amendment, and currently we are in the process of amending the law, and the bill was first introduced in Lok Sabha, and subsequently it was referred to a parliamentary standing committee, and now the bill has been passed by the Lok Sabha, and it has to be debated in the Rajya Sabha. So very shortly, we should have the amended version of the law in force.
So it's been amended many times, and but the act has been active for the last 50 years. So what would you say is the significance of this act for India's wildlife and for wild habitats?
It's been hugely important for the simple reason many people often dub these laws as colonial and so forth. at least when the forest reservation process started, the Forest Act was dubbed as a colonial legislation, colonial government, and so forth, because 1878 was the first Indian Forest Act, and then the 1927 Act is still in force. Whereas what happens is the situation in 72 when this act came into force was extremely serious. Many animals were on the verge of extinction. And mind you, the context at that time was that there were no development pressures like what we have today. It has drastically changed. So habitats were intact to a large extent as compared to what it is today. So the Act provided a framework for two very important aspects for protection. And the word protection is used in laws that are primarily prohibitive in nature. For instance, the Forest Rights Act, which enables everything, it's an enabling legislation. Whereas Wildlife Act says you can't do this and that and that. So it's prohibitive. So under this law, two important aspects happened, or rather the law covered these two aspects. One, protection to habitat in the form of notifications as national parks and sanctuaries, and introduction of penalties for, first of all, the ban on hunting, complete ban on hunting of animals listed in the 4 schedules, and the enabling provisions with respect to trade of wildlife products, which was made illegal after the enactment of this law. So, forest officers, for the first time, dropped their felling hammers and started going out and protecting wildlife, both habitat as well as wild animals. And the sustained efforts of the Forest Department over a long period of time, and Forest Department at that time was very different from what it is today, because we need to understand this also. They were extremely dedicated forest officers and who were on the ground, which it is very important. You may have any designation, that doesn't count, as long as you have field knowledge and understand field realities. You can't manage a national park from using an iPad. Let's forget it. And that's what it is reduced to today, unfortunately. The best technology, I'll digress a bit, the best technology did not help America win the war on terror in Afghanistan. It was just rudimentary field superiority of the Taliban, which beat back the best equipped army. So even out here, if I were to tell you all that foot patrolling is the centerpiece of the protection efforts in India, some people may say, hey, what is this? This is some archaic or antique thing. No, it is foot patrolling that is required. And all your drones and all come. I am for technology. I'm not anti-technology, but without solid field knowledge, you can't manage these parks. And at that time in 72, the officers had that knowledge and they notified areas. So today, over a period of time, approximately about 4.5% of India's landscape has been notified as national parks and sanctuaries. Roughly about 2 lakh square kilometers of forests are under the protected area network. 2 new categories of protected areas were added, that is conservation reserves and community reserves. And in the 2006 amendment, tiger reserves got legal status, because tiger reserves existed even prior to 2006. But that was just an administrative order to provide funding from Project Tiger. But it received statutory status only in after 2006. And if I were to, let me clarify, because there's a lot of confusion regarding what is a protected area and what is a tiger reserve. In India, all tiger reserves as it stands today are either a national park or a sanctuary. So its status as a tiger reserve doesn't take away the fact that it is a sanctuary or a national park, as the case may be. So in net effect, a tiger reserve is also a protected area. So under the Act since 72, we have today notified about 4.5% of India's landscape, which is still minuscule, as protected areas, where a strict anti-hunting regime is in force, and a sustained effort has helped protect wildlife. Yes, there are a lot of gaps, as we will discuss later, but at least without the Wildlife Act, one can safely say, irrespective of other views, there is a view that, okay, let us hand over all forests to Gram Sabhas. They will manage it. This is like saying that let us hand over all RBI vaults to taxpayers associations. After all, it's our own money. So we'll operate the RBI vaults and have keys. Let every member be given a key. Does it work? It doesn't. It's as bizarre as that. So we need an agency, a professional government body to manage and protect these areas. Community support is certainly required, but that's a second line of defense. This is because the illegal trade in wildlife is second only to narcotics. And people are not going to smile at a Gram Sabha resolution and pack up and go away. They're going to be around. They're linked to hunting syndicates, trade syndicates. It's a transnational crime and transnational trafficking in this. And therefore, we need to get serious. We can't be naive in our understanding. And there was one very well-known person recently who said the Wildlife Act should be thrown into the dustbin. So I'm of the clear view that we need the Act. The Act has done its job. Yes, implementation has been up and down. And we'll come to that. I think we are going to talk about implementation. But the Act has ensured that we have saved species, we have held on to certain important habitats, and without that kind of legal protection, it would be impossible for us to have reached or hung on to what we have today.
I think it's what you mentioned makes it seem like it's so crucial that the act was passed 50 years ago and not today, right?
Absolutely.
Yeah.
Many charismatic species would have disappeared, in my view, if the government of that day had not acted. And most importantly, if that disciplined Forest Service had not gone out and implemented the law. The political situation is also very interesting. We do have such a political situation even now. Mm-hmm. At that time, the Congress party was in power. Indira Gandhi was the architect of the Wildlife Act. She was a naturalist herself. And they were out of at that time, probably 28 states or so, Congress was in power in 24 states. And the writ of the Prime Minister ran right to the office of the Chief Minister. That was the context in which the Act was enacted and implemented also. Today also we have this situation. And that situation, unfortunately, this perception that wildlife protection will hamper or come in the way of development, it's a perception. It is not the case actually. That is probably, in my view, impeding a stronger approach to conservation.
I have a lot of follow-up questions based on everything you said, but okay, I'll come to the next question, which is it possible for public spirited citizens to defend wildlife habitats using the Wildlife Protection Act?
Absolutely, and it is the need of the hour. I'll tell you why. First of all, even before what a citizen can do under the Wildlife Act, we must clearly understand that we have a very strong constitution, and all laws have to conform to the constitution. Otherwise, they'll be void. Now, the Indian constitution has several important aspects. And one most important aspect is fundamental rights. And under Article 21, the Supreme Court of India has expanded right to life to include right to clean environment and ecological balance. So it has now become a fundamental right, apart from being a fundamental duty to protect forests, rivers, lakes, and wildlife under Article 51AG. And there are directive principles of state policy, Article 48A, under which the state is bound to protect forests and wildlife. So this is the legal framework. And there are several other fundamental rights for people, public-spirited citizens. The right to freedom of speech and expression. Because if you have to express your view on a certain government policy, you can do so fearlessly, as long as you are sticking to criticism of the policy and not calling people names or calling decision makers names or getting into the realm of defamatory statements or getting into the issue of inciting violence. Apart from this, you're free to criticize government policy. You can't do this in North Korea. You can't do this in many nations, authoritarian regimes. The democratic and the constitutional rights that citizens have must be utilized, but utilized responsibly. You can't go and start calling people names and so forth, then you face the law. So every citizen is empowered under the Constitution to protect forests and wildlife. In fact, it is also the fundamental duty. Apart from this, how does the Wildlife Act itself directly help or support citizenry or activists to protect wildlife? See, first of all, in continuation with constitutional provisions, there are positions that have been created for citizens who may be ecologists or who may be experts or who may be non-governmental organizations to serve on the National Board for Wildlife or the State Board for Wildlife or as honorary wildlife wardens. So therefore, on these important and even on the National Tiger Conservation Authority. So as expert members, one can contribute in policy making, in decision making pertaining to wildlife and its protection, because that's the mandate of these boards, the National Board, State Board, and the NTCA. Honorary wildlife wardens are more on the ground level, trying to assist the officers in protection and so on. So this is one aspect which the Wildlife Act enables. The other is, for instance, there are many who would be interested to know, how can a highway project be stopped? How can a mining project be stopped? And under which provision of the law can one intervene? So the answer to this is as follows. The Wildlife Act contains provisions, for instance, in case of sanctuaries, Section 29, and in case of national parks, it is 35, subsection 6. What do these sections prescribe? It simply states that there shall be no destruction or diversion of water from a national park or sanctuary unless it is for the improvement and better management of wildlife therein. So when the state board or the national board considers a development project, be it a highway, be it a mining project, etc., it will have to answer as to how that project, that highway or the mining is benefits wildlife. So this came
This
up
is
for
only the
debate.
case if the project is inside a protected area, right?
Correct. In case of a sanctuary or national park. So this question came up. Many a time, I've had people talking to me, and I was myself on some of these committees and so forth. Often the question is, people will say, "Oh, I've dissented." Yeah, dissent is one thing on the committee, but that doesn't take away your right to question, of course, in a civil manner. How is this statutory body allowing destruction when it is not benefiting wildlife? So it is very important for non-government individuals, experts who are on these committees to record their objections. In fact, very recently in Bangalore, the Hesarghatta campaign was on, and one of the members of the State Board for Wildlife, I think he is on this meeting, he had given his opinion in writing, and that was quoted in the High Court order. And the person who went to High Court is also in this meeting. I can see his name. And the court recorded that the expert committee, the state board members have recorded this objection. So therefore, it is important to record it and cite provisions of law which are important because you are performing a statutory duty. So this is one. So section 29, later when the public spirited citizen wants to challenge it in a court of law, it can go to the court and say that, look, section 29 stands violated or section 35(6) stands violated. There are other provisions. For instance, in chapter 4b, there is a provision under section 38 OG, which says that areas connecting one protected area or tiger reserve to another protected area or tiger reserve shall not be diverted for other purposes except in national interest and with the approval of zones. So that also is a provision which public spirited citizens can use in a court of law to say that how is this mining or highway project, when it is cutting through these areas, how is it beneficial to wildlife? So the question of what is benefit to wildlife also was debated. India is full of committees. For any problem, you form a committee. This is the government response. Anyway, so there was I think it's still there, a committee called as the Boundary Rationalization Committee. I happen to be part of that. The question came, and this is exactly what we raised. Two of us were familiar with law, and we raised this question and said, look, 29 and 35(6) prohibit. How can we allow this? And then a procedure was formulated, at least when our committee was in place, that an area at least double that of the area to be diverted has to be added to the same protected area or at least to some other protected area in the state in order to comply with 29 or 35(6). And we should explore all other options of diverting the project elsewhere. So we dealt with proposals on that committee in that manner. but now I'm not sure what is happening. Going by the rates of approvals on the standing committee of the NBWL, it is over 95%, and it's been literally turned into a clearinghouse. But the law has not changed; it's the same law. So therefore, so citizens can use this. For instance, there are provisions where citizens can support efforts of the government or a law enforcement officer and can provide assistance to the law enforcement officer legally. This is also provided under the law. So there are many provisions where citizens can get involved. I already mentioned about honorary wildlife wardens. So they also can work on a day-to-day basis. Then research. Research is an important aspect because we need science-driven conservation. I'm very clear about this, and I've been saying this for a long time. And there are enabling provisions for research. Of course, there's a lot of bureaucratic issues that researchers face with their permits and so forth. But still, the law does provide for research, and one should, of course, follow all the rules, etc., etc. So the law does provide for it. Yes, I'm fully aware of the issues that researchers face in terms of research permits and so forth, but that's more of a problem with the bureaucracy and not with the law. Of course, we have tried to seek amendment. Even the Parliamentary Standing Committee has given its own opinion on these aspects. We'll wait and watch to what extent it's going to get, it's going to improve. So citizens can participate, and the Constitution, as I've been repeatedly saying, under Article 32 and with respect to the Supreme Court, and under Article 226 with respect to the High Court, public-spirited citizens can go and even challenge a law enacted by the central government or the state government, as the case may be. You can challenge any aspect, but frivolous petitions are dealt with very seriously. And there is a process that one has to follow before invoking these extraordinary rights. You can't just rush to court with an Indian Express article and some journalist having written that there is some destruction going on. You need to first exhaust your administrative remedies or statutory remedies, approach the Chief Wildlife Warden of the state and collate data, start a campaign, and if nothing has worked, then you can approach the court. You can't just rush to court. Now, with respect to criminal prosecution, the Act has a very interesting option for citizens. I don't know if anybody has used this, but I always tell them. Supposing, let us assume that there's a very strong group and a lot of activists, and maybe there's a lawyer also in a district headquarters, which is close to a national park. And that group has found that a tiger has been killed and the death of the tiger has been hunted, and that hunting case has been suppressed and not reported. If they pick up proper evidence, they can prepare a notice to the Chief Wildlife Warden of the state under 55C of the Wildlife Protection Act. And if the chief and adduce the evidence that they have gathered, it could be photographs, it could be other things. And if the Chief Wildlife Warden does not act on that notice, the group or the individual can approach the jurisdictional court, magistrate's court, and prefer a complaint, and the process of a criminal case is set in motion. This is a hugely useful thing where officers are refusing to investigate, a wildlife crime. So these are, I can go on, but uh, these are some of the provisions that empower citizens to work for wildlife conservation. There's a huge bandwidth of options, and therefore you need to use it to protect wildlife. Because let's be clear, we as wildlife conservationists cannot uh, get 2 lakh people to sit somewhere and protest. It is not possible. You may do any amount of online campaigns, 5,000 signatures, 20,000 signatures on this and that and whatever. I know there are many online platforms. Nobody is going to take that seriously. So the issue is, and just saying this on something, you liking it, not liking it, doesn't matter. At least it doesn't matter to decision makers. But only when a court of law interferes, that is a constitutional court, and constitutional courts are either high courts in states or the Supreme Court. I'll tell you why I'm saying this, because NGT may not be the forum in many cases. For instance, in wildlife, it's a long subject, but I'll just make a short point that NGT does not have jurisdiction under the Wildlife Protection Act.
The National Green Tribunal, right?
Yes, it does not have jurisdiction under Wildlife Protection Act. And it is not a constitutional court. So, which means that you can't argue on a constitutional aspects of something. So therefore, approaching the High Court or approaching the Supreme Court, as I mentioned, would be a better option to protect wildlife. But on the rider that you've done your homework and you are going there with a serious issue and with data, with facts, maps, satellite imagery analysis, blah, 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 what have you. So citizens have all these options, and therefore there is no, what shall I say, nobody need to be disheartened that, oh, we can't do anything. You are empowered.
So I have 2 follow-up questions for this. So the first one is, if someone like me, for example, if I was to take and challenge some part of the law and take it to the High Court or the Supreme Court, historically, how successful are these challenges? And also, the second question I have is, I hope you don't mind if I take a very specific example. For example, the development projects which are being planned in Nicobar. So it can researchers and people like us, can we help to, challenge those clearances that have been given?
The answer to both is yes. In terms of what is the success rate of if somebody challenges a law, which was the first part of your question, I don't have any statistics. But as long as you are able to establish to the satisfaction of that constitutional court that the law has been, the following flaws exist in the law which make it ultra vires the constitution, or the enacting state, which is, it could be the state government or the center, does not have legislative competence, you will certainly succeed. A. B, your Nicobar thing, one has to look into the facts. The law is in place. I haven't followed up that matter, but I'm pretty certain that I just read very briefly, which was sounded quite bizarre, that for 120 odd square kilometers or whatever it is that's going to go in Nicobar, the compensatory afforestation is going to happen in Haryana or in Madhya Pradesh. This is what one media article said. I don't know whether it is correct or wrong. But these are things which courts view very seriously. Because every government, as I said earlier, has a constitutional mandate of protecting forests and wildlife. And it must apply its mind correctly. If it acts arbitrarily and without application of mind, courts take it very seriously. But you have to establish that they acted without application. That responsibility lies at your end. And as long as you can collate a proper case, you can, and then of course you should be backed by good lawyers. And there are lawyers who are doing pro bono work. You don't have to spend from your pocket. And you must take credible cases to them. And then good lawyers are going to back you up. That's been our experience. And therefore, you can intervene. There's no problem whatsoever. But you must also, NGOs must be careful, because you must, first of all, your organization must be in conformity with law. Your funding, your legal requirements, what are the legal issues that you need to comply with, you must be very clear. And your integrity must be beyond question. Because when you start questioning governments, there's going to be a backlash. And as long as your house is in order, you can face it. You can answer it very clearly. So this is important. But when your house itself is not in order, you start throwing stones at somebody else, you're bound to face issues.
So you were talking about how the Wildlife Protection Act, it prevents the illegal trade of wildlife, and it has penalties for hunting and these kinds of things. So how well is this act enforced in India? And since it's been established, has enforcement improved, and is there more room for improvement?
Enforcement, in a general sense, it is difficult to say one way or the other, because enforcement can vary from a forest, one range in a national park, to another range in a national park. It can differ from a national park to another national park in a state. So it will be very difficult. And also, as officers change, in a particular field level officers change, the enforcement levels can go up or down as the case may be. But overall, at a very general level speaking, as I said earlier, the Act has helped protect wildlife. Enforcement has happened. A lot of people have been prosecuted. And therefore, the fear that one can get involved and one can be booked for up to 7 years under the law, that fear is there. People are aware now. And cases are happening. Of course, there are problems with respect to cases in terms of investigation, prosecution, procedural aspects, because Forest Department is not a trained agency in investigation. They don't know procedural law. Without knowledge of procedural law, prosecution in wildlife crime suffers. So I can't go into the details of it because it's too short and it's too complex. But wherever officers have put in good efforts, the law has helped them in curbing wildlife crime. And at a very broad level, one can say that there is some control today on wildlife crime. Our serious problem today is fragmentation of habitat caused by development projects. So to sum up, I would say that A, as I said earlier, Act is absolutely necessary. B, there are agencies empowered, and it is not just the Forest Department. For those who are unaware, wildlife crime, including illegal trade, both police and forest departments have concurrent jurisdiction. And police, as you all know, have a much larger presence across the country than forest departments. And a lot of trafficking happens through bus stands, through railways, etc. So it is very important, and the Wildlife Act empowers police officers also. Of course, there are other agencies, border security force and so forth. All of them can intersect. Now there are amendments where the Coast Guard is being empowered. So, with respect to species that could be smuggled across seas. So therefore, let me conclude by saying that yes, enforcement is happening. One can't specifically pin down and say which state or which area, but overall it is happening. It can be much better, but it is still happening.
Okay, so in the last 50 years, the law has undergone like so many amendments. So what do you think are the most significant amendments, and where do you see this law in the next 50 years? Are there like additional changes that need to be made?
Of course, there are changes. Law has to evolve because it's a dynamic subject. So a lot of things change. In terms of the big amendments that have happened, 2003 amendment, which came about, was an important amendment because it gave statutory status to tiger reserves. And earlier, and there was an introduction of a new clause which empowered forest officers to deal with encroachment, Section 34A. There was also a very big chapter introduced which has hardly been used. That was the 2003 amendment, that forfeiture of uh, property derived from wildlife trade. It is very similar to provisions in the Prevention of Money Laundering Act. So it's a very strong chapter that has been introduced. It's still there. So these were some important amendments that happened over a period of time. And in the next 50 years, we need a lot of amendments for the simple reason that today, in some cases, we are finding, for instance, management plans drawn by forest departments or tiger conservation plans. They lack scientific rigor. And the kind of money that is coming into national parks and sanctuaries is huge. We don't need that kind of money. So it is triggering a whole set of problems from the custodians themselves. Bulldozers and excavators are running amok in some of our national parks. What role or what place does a bulldozer or an excavator have in a national park? So these are questions, these are problems, and as the law evolves, and it is bound to evolve. For instance, right now there's a debate going on CITES. Whether CITES should be in the Act. For all people who are on this webinar, please read the Parliamentary Standing Committee report. The chairperson of the Parliamentary Standing Committee requested me to draft a response to the rationale put out by the ministry, and it's in writing, it's gone to the ministry, as to why the Act must not include CITES. CITES can be a separate law, or the concern of CITES to give, to improve or bring it within the legislative ambit can be taken care of by very simple amendments to the existing law. And for those who may not be aware, CITES is only a regulatory mechanism. Our Wildlife Protection Act is much, much stronger. It has a prohibitive structure. And fundamentally, when you include or push in a regulatory framework into a prohibitive law, it is going to cause problems. So you can read about it. So we need to resolve these aspects as we go along. And we may at some point in time even go the American way, where you may not have one law uh, governing all national parks and sanctuaries in the country. In America, every national park is constituted by a separate act of Congress. And there is an overlapping law called as the Endangered Species Act, where species come in or move out of that. That's a federal law. Whereas Shenandoah National Park has a separate, is constituted by a separate act of Congress, or Rocky Mountain. So what is prohibited in Rocky Mountain may not be prohibited in Shenandoah. So these are all aspects. As we go along, we'll evolve, and changes are going to come about. But let me say, even 50 years down the line, if we try to dismantle the protective framework, wildlife is going to suffer. Because as we go along, we are going to lose more areas. And therefore, the law is very important, and any attempt to dilute the law in terms of denotifying areas or pushing, giving lesser protection to animals in terms of loosening of procedural aspects and so forth. I'm not talking of penalties. I'm not a big supporter of this idea that you give life imprisonment or death penalty. No court will give it. It all depends on quality of evidence. They're going to demand a very high quality of evidence, which our investigations in wildlife cannot meet up. And therefore, people will go scot-free. 3 years, 5 years, judges will be willing to convict people. So that apart. So you need this framework. We need to watch very carefully and act as watchdogs to ensure that the protective framework is not dismantled. And as and when changes are required as we evolve, climate change is the talk of the town. But the response, nobody is factoring in old growth natural forests. It is not being given the importance that it deserves, which are our national parks and sanctuaries, and the amount of carbon it's already sequestered, and so forth. Everybody loves digging a pit, buying a polythene bag, raising a nursery sapling, and planting. This is detrimental to protection, and the money flowing into developing and third world economies. Even COP27, I was seeing that there's money. We certainly don't need money for our national parks. The less money, the better, because we are getting too much of money. So throwing money at a conservation problem is not the right approach. So let us see how it evolves, but I certainly want that and hope that citizens are going to watch for any attempts to dilute the existing law, particularly at a time when it is undergoing amendments.
So we have a question from the audience, which is, what are the major loopholes of the Wildlife Protection Act, and is there any ongoing amendment to overcome these loopholes?
Loophole, every law has loopholes. No law is free of loopholes. But the point is that wildlife law also has loopholes. Now, if you were to ask me, I'll have to go into very, very specifics of for instance, currently there's a debate, and in one state government has said, no, we don't want police to investigate. We'll do our forest department is competent to investigate. They are trying to exploit a particular loophole or a rather vague aspect of the law. So, but then the Supreme Court has clearly held that police officers are also empowered. So this is from within. The other aspect is about the loophole pertaining to, as I said, about 29 and 35(6). We need to be very careful while appraising development projects. And their loopholes are being adopted to clear projects. So this is something that we need to watch out. So no law is without loopholes. Now, some of these, the procedural aspects, for instance, now I'll have to get a little technical. This is pertaining to criminal prosecution. The conventional crime is prosecuted based on the Code of Criminal Procedure. Under that, the first document filed in court is called as an FIR, or First Information Report, which is lodged under Section 154 of the CRPC. And the final report, which is called as the police report at the end of the investigation, is under 173 CRPC. Now, Wildlife Act does not provide for this procedure. So there is massive confusion on the ground as to what is the document to be filed. So Karnataka High Court, for instance, clarified this. It's in my book also, I have clarified it, that the first document has to be the Wildlife Offence Report under Section 50, subsection 4. So this is also, I submitted this to the Parliamentary Standing Committee and it is included in the report. It's unfortunately not in the bill before which has been passed by the Lok Sabha for reasons that I don't know. So some of these are being addressed, and but then it could have been much better. A lot more could have been done in terms of plugging loopholes.
Another question that we have is, why are the Forest and Wildlife Acts in different legislations? Why are they not in one consolidated act?
Because they are two different separate fields. And there was an attempt in 2014, and the government of that day appointed a committee headed by a former cabinet secretary, Mr. TSR Subramaniam. It was called as the Subramaniam Committee. And the terms of reference of that committee was merge all laws in the field of environment into one law called as the Environment Law Management Act, ELMA. But that proposal was shot down by the Parliamentary Standing Committee, thankfully. See, Wildlife Act is different, Forest Conservation Act is different, Indian Forest Act is different. So we need laws, but they complement each other. I'll tell you how. For instance, the Wildlife Protection Act does not define what is non-timber forest produce or minor forest produce. It merely says that forest produce shall have the same meaning as in the Indian Forest Act. So you go back to the Indian Forest Act and draw the meaning or definition of what is forest produce. So sometimes these linking happens, and notification of a reserved forest is different from notification of a sanctuary or national park. So these laws have to be separate and it can't be merged, in my opinion.
So one question that is there from our audience, and this is a question that I also have, is what is the actual difference between a reserve forest and a wildlife sanctuary or a national park?
Yeah, good question. So I did mention briefly about the different kinds of protected areas earlier. Most of our forests were notified at turn of the century and subsequently. And those forests that were notified under the Indian Forest Act are called as reserved forests. Now, there is a detailed procedure prescribed under the Indian Forest Act which starts from a notification under Section 4, and the final notification as a reserve forest happens under Section 20. So, and let me point out to people that there is an allegation that under the colonial system, the rights were never recognized. Please read reserved forest notifications. It is a detailed settlement process that has been traversed, and what we call as speaking orders as to who made a claim, what was the claim, why is that claim admitted or rejected. It is all recorded, and the boundary descriptions are so clearly done. It says from a point at the tri-junction of the stream and the road, the line will run in a southwest direction for 13 chains. It goes on into such details. I can go on and on. So the point is that these detailed settlement process was traversed, and only then were reserve forests constituted. And let me also tell you that when the reserve forests were constituted, if for an equivalent amount of forests, or sometimes up to 4 times the forest area taken up, was left out for community. Where has that gone? You can dub it as colonial law and say, but if they were not notified and protected, all those areas also would have gone. So the first notifications happened under the Indian Forest Act, and they constituted reserved forests. Sanctuaries and national parks came subsequently, though some sanctuaries have been constituted under the Wild Animal and Birds Act, so forth. But after 72, 3 or 4 reserved forests were amalgamated, and an overlapping notification as a sanctuary or national park was issued. Subsequently, after 2006 amendment, another overlapping notification as a tiger reserve was issued for the same area. So, in other words, the area can be a reserved forest and a sanctuary and a tiger reserve. So none of the earlier notifications go away. They don't lose its legal status. So the area still remains a reserved forest and also a sanctuary and also a tiger reserve. So this is the difference. And then there are other differences. I don't want to go into it because we don't have time. Like what is a buffer zone, what is a core zone, etc., or what is an ESZ and all that. So, and let me tell you, ESZs, there's a lot of debate on ESZs, and people are saying, oh, ESZ, you lose your house, you lose your land, etc. Environment Protection Act has no power, or rather does not empower any government to acquire any land. So the question of people losing land doesn't arise. Whereas under the Wildlife Act and under the Indian Forest Act and the State Forest Acts, there is a procedure prescribed, and the state government is empowered to acquire lands if required, following due process. So this is as far as the ESZs are concerned. It's a small aside. So this is the difference. So the first notification is a reserved forest, subsequently a sanctuary, and then a tiger.
So does that mean reserve forests have less protection than wildlife sanctuaries and tiger?
See, the Wildlife Protection Act, the provisions of Wildlife Protection Act pertaining to habitat does not apply in reserved forests.
Okay.
So the Forest Conservation Act applies there. The clearance process adopted, if one were to divert habitats within reserved forests, the FC Act, the Forest Conservation Act process would apply. Whereas in case of a notified sanctuary, the wildlife clearance process applies. Both are a little different.
Okay. So we're running out of time now because it's 7 p.m. So Just to conclude, I have two final things, like questions I want to ask you. So the first one is that are there any resources that we can access to read more about these laws or to understand these laws better? I mean, of course, the actual laws are available for us to read, but do you know of any resources? And also, do you have any final, concluding remarks for our audience in terms of, the
Yeah,
laws and how to
yeah.
engage with them and all of that?
No, I'm very happy that so many people are participating and trying to understand these issues, and CWS has taken interest in trying to uh, create this platform. Uh, in terms of resources, conservationindia.org is a good platform where there's some good credible material, both in terms of science and in terms of legal aspects. So that is one resource. We are also revamping it, and I'm associated with that. And we are going to put out additional material on laws and so forth very shortly. If one is interested in understanding criminal prosecution under the Wildlife Act, there's a published book of mine, Wildlife Law for Rangers. One can pick it up. And there's another book of mine coming out shortly in the next few months, Wildlife Law for Conservationists, where all the aspects of how to use the bandwidth of various laws, for instance, the RTI Act, many other things, the Wildlife Act itself, state forest acts. So all that is covered. So two broad target audience, different audience. One only for law enforcement agencies. Of course, those interested conservationists can look at that. So that's going to come out, and I'll share that information. And that's still, it's ready, but it has to be, it's in the final stages. So that's about it. So all that I'll say at the end is that we need to rationally approach this. Mere breastbeating is not going to help us. And just jumping and trying to do something is not going to help us. We need to have a nuanced approach. And this is where I firmly believe that ecologists and activists must come together. And because ecologists will do their research, yes, they'll publish a paper, they'll give their report to the government and say, okay, my job is done. But wherever ecologists have collaborated with public spirited groups, civil society, and so forth, a lot of meaningful conservation has happened. We need to be very, very, what shall I say, equipped in terms of how to approach a problem. Because we are sometimes, I know for a fact that groups are pursuing non-issues. And what happens ultimately is the government will wield the stick and say, hey, what are you people doing? You're trying to stop everything that we do. So let us not get to a situation where we lose our rights, such strong rights that we have, by acting irrationally. So we need to be knowledge driven, and we need to consult people who are knowledgeable, collate data, and then go in a graded manner in terms of campaigning and ensure that whatever can be saved is saved.
Okay, I think that's a great message to end the webinar on. And if the people attending this webinar, if you have any questions for Praveen, you can contact us at outreach@cwsindia.org. You can also send your questions to me at vinni.jain@cwsindia.org, and we can send your questions to him and he can answer them. But thank you so much. That was very interesting. Everything you said, it was like, there's so many misunderstandings and miscommunications when it comes to issues like these. So it's really nice to talk to someone who is so well versed with the laws. So thank you.
Thanks a lot. My pleasure, and hope it was of some help to everyone. Thank you. Bye.
Thank you. Thank you, everyone, for joining.
Bye.